And the last year when I argued the matter, the present Chief Justice asked the State Council, you must categorically answer this. And for that only 10th is a get fixed.
No, categorically answer what?
That the creation of supernumerary post is an outcome of corrupt practice.
Now, where is the division bench judgment observation?
This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Now, I have already held so.
But kindly look into two of my affidavits, Miller. Your Lordship has been pleased to, Miller, defer the hearing of the matter. In view of the submission made that the matter pending before the Supreme Court also incidentally deals with this. This is what has been said. Now, subject to correction by my learned friend, I do not know what is their reply to these two affidavits which have been filed almost 1 year back. Now, please take, Miller, that the affidavit of...
Already been filed or it will
No.
be filing it?
No, I have filed it. It's on record. 13th of February 2024, it has been affirmed. Osim Das,
We have our, my lord, we have our reply also.
Hmm.
You have filed your reply?
Yeah.
No. Because your lordship, if I correctly remember, subject to correction, this affidavit was not accepted by your lordship because the queries which your lordship's put was not there specifically. That's why
So, my query to erstwhile Advocate General was that the issue which was travelled prior to the division bench judgment of the designated bench judgment, observation of the designated bench judgment, that the CBI inquiry on the affidavit of the SSC. The SLP was admitted and stay was there. My specific query before just to the erstwhile Advocate General was that can you assure this court that even incidental, because the scope of challenge was that who has created this post and what was the cabinet decision, all these things are there and CBI to inquire. Incidentally, the power of the state to create supernumerary post would not be an issue before the Honorable Supreme Court. Matter was adjourned. Learned Advocate, erstwhile Learned Advocate General took specific instruction from the Council for the State in the Supreme Court, say no, this much assurance it cannot be given. Obviously, it cannot be given. The challenge before the court is that state's power to create supernumerary post is supernumerary. Then, obviously, this was deferred. Again, this same question was put. The affidavit, if it is that affidavit was filed, but I asked Justice the Advocate General that this is not meeting my query. There is no clear-cut answer to that. Now I know that it is very difficult to give this answer. You don't know while hearing of this SLP, the Honorable Judge will not go into that question that how you have, why it has been created. There is another question, how it has been created. There may be an incidental question. When the division bench, so far I remember, had made certain observation regarding this creation of supernumerary post. It is not that possibly that in respect of which to accommodate which kind of candidates the supernumerary post has been created. The observation was covering your power to create in the division bench judgment. So challenge to the division bench judgment before the Honorable Supreme Court, unless takes a final shape, whether it would be proper to deal with the issue or not. This I'm troubled by this issue now.
Milord, your Lordship has been pleased to, Milord, put it in a most confined way as it could be. Here, Milord, the challenge is page 300 of the writ petition and 302 of the writ petition. What is the challenge? That certain number of posts have been created, partly for the physical education teachers and partly for the work education teachers, and according to the writ petitioners, who are obviously unsuccessful persons, they now question the propriety of creating these supernumerary posts, as they call it. Please have a look to your.
No. As they call it means, are you not saying that this is a supernumerary post?
No, I'll come to that. Why it should not be called as supernumerary post, that I'll come to that. Now, please have a look to your Lordship's order of 18th of November 2022. But I'm bound to answer to your Lordship's query or the to clear your Lordship's doubt that whether the pending SLP is standing in the way of your Lordship hearing this matter or not.
Yes.
But kindly have a look to the order of 18th of November, when your Lordship was pleased to, my lord, pass this order of injunction. Please take the second paragraph of the first page. The power of the government to create so-and-so supernumerary post to fill up the post of so-and-so, including physical and work education teachers and non-teaching staff in the so-and-so schools, to accommodate the waitlisted candidates with the order of 19th May, as well as the validity and legality are under challenge in the present writ petition. Now, this is the challenge. Dr. Patro, Learned Counsel for so-and-so, submits that against the post so created, the names of 514 candidates and 766 candidates have been recommended for appointment in the post of so-and-so, respectively, to the board. In creating such supernumerary posts, the procedure prescribed under the Act and the rules prima facie have not been followed. Therefore, so-and-so are restrained from issuing any appointment letters to the candidate in respect of the post till such and such. Now, this has been extended from time to time. Now, my lord, whatever, my lord, your Lordship was pleased to, my lord, prima facie observe, my lord, for the purpose of grant of this interim order, my lord, we are all bound by that. Now, my lord, this is of 2022. In the meantime, many other matters were heard, various other orders were passed, matters went to Supreme Court, came back, again went to Supreme Court, etc. Now, my lord, the point that is being taken today is that a matter is pending before the Supreme Court. Therefore, this court should stay its hands in hearing this writ petition, on the ground that incidentally, the Supreme Court may have the occasion to consider
This was when this interim order was passed.
Right.
Now, this has matured a little bit more. Have you got the copy of the division bench judgment?
But I have right now. I'm aware of it. Right now I
Yes.
don't have.
That observation.
Right.
That observation
Right.
regarding supernumerary.
Yes. Now, please have a look to my affidavits. 2 paragraphs from
You have
each
not
of.
filed it. Rather, I did not accept it because this does not
No,
satisfy
but
my need.
he's. দেয়া হয়নি এই রে
Possibly, I did not repeat. But my query was a very clear-cut answer from the state. A very clear-cut. You have to write that the pending matters, in pending matters, these are not issues and would not any remote possibility of raising these issues in this pending matters.
Milord, please, since Milord, it is still lying with me, please have a look at it. If your Lordship feels, kindly take it on record, or else I'll take it back. Please have a look to me 13th February 2024.
No, I have not accepted it. Let me see what he wants to show.
But please have a look to me paragraph 4, second page. অন্যটার অরিজিনালটা ফাইল হয়েছে এটা The issue involved in this case is not directly associated with the proceeding before the Honorable Supreme Court in SLP, diary number, etc., passed by the Honorable Division Bench of the High Court at Calcutta in MAT so-and-so.
This is the designated bench judgment.
Yes.
This
Yes.
is the designated
Yes.
bench judgment.
The proceedings pending before the Honorable Supreme Court is in relation to filling up of the Group D posts. The 1,600 number supernumerary posts so created by the order dated so-and-so for the work education and physical education teachers are required to be filled up for the benefit, etc. Your Lordship may skip over that.
No. Paragraph 4, as you have rightly said,
Yes.
is not directly associated. My query from the erstwhile Advocate General was whether this issue can incidentally be raised in the pending SLP, means SLP against the order directing CBI inquiry. This affidavit is coming when the division bench has already passed the order, making certain observation
Right.
regarding creation of supernumerary post.
Yes.
Now both these, it has travelled to Supreme Court from both ends. One from the CBI inquiry, the other from the division bench judgment, annulling the entire selection process or like that.
Right. Now, our case is that, Milord, this has got no connection with the whatever is pending before the Supreme Court. Now, Milord, if I am posed with this question as to what Mr. Bikash Bhattacharya will argue in one matter in Supreme Court, day after tomorrow, I cannot say that.
Mr. Doctor, you plan to clearly say, I will record that this issue.
Milord, I am, with respect, Milord, I have been asked to, Milord, answer a query which ought not to have been put to me.
Why?
What the Supreme Court will consider tomorrow.
Then,
Yes.
already I have held, tested in appeal that
No,
this
it-
prima facie appears to be related with.
Milord, it's not a question of testing everything in appeal.
I'm
Yes.
telling you,
Yes.
I have given you the avenue
Yes.
to test it in appeal that this is not. Mr. Dotto, this is very clear
Yes.
that I have to put you this question.
Yes.
Two things.
Yes.
Today, directly, whether you are interested to absorb or appoint any person in against the supernumerary post so created, because the one occasion the stand of the state was we are at present we are not possibly
Yes.
this was the stand of the state at one point of time. Now, huh?
No. It is not before the Supreme Court. I do not know what is being said. If it is not there, no. It's not a question of instruction. He should bring out any order of the Supreme Court to this extent.
No, bring out is one thing. Now, if you think that this is my observation, it's subject matter of challenge. The present writ petition prima facie appears to be related with the said pending special limb petition.
Prima facie.
Therefore, please clarify from the division bench or from the Supreme Court. No, this issue is not. I am not.
Please consider one thing,
Mr. Doctor, you understand the problem of this court is because the vacillating stand of the different councils. The statutory bodies are taking one stand in High Court, the other stand in the Supreme Court.
But go by my pleadings. Please don't go by what I say in court. Please go by my pleadings. Please take my affidavit in opposition. And please, Milord, form an opinion on that.
Already I have formed a prima facie opinion.
Yes. Now kindly see, Milord, there are other affidavits which have come. Now, because, Milord, the point is, Milord, 10 people come over here and we are obstruct
Mr. Dotto,
1,000 people.
Dotto, yes, of course. The persons who have already been recommended for appointment,
Yes.
appreciate their anxiety. But this situation has been created because of this, I must say, the vacillating stand of the authorities. Either they may say that yes, we are ready and willing. Possibly you are not there. So far I recollect, there was a statement or submission on behalf of the state that at present we are not going to absorb any of the persons against the supernumerary post. Where is the division bench judgment? Show me that particular, Mr. Dasgupta, show me the particular area.
Division bench.
Justice Bosha's division. Achha.
May I just try to clarify? I think
Yes.
an advocate is also not properly briefed with
Yes.
respect. Now, the challenge before the Supreme Court was the cabinet memo by virtue of which all these supernumerary posts are created.
Let the SLP be produced.
Okay.
Mr. Bhattacharya goes with that SLP every alternate week.
SLP, before the
That is never produced in court.
SLP, the learned counsel, well, we have to believe the learned counsel. Now, when the live streamings are there, anything can be restored. Categorically stated before the Supreme Court, please stay the CBI investigation. State is not appointing anyone from these supernumerary posts created. Number one. Number two, then again, we could not also appoint because the Honorable Justice Bishwajit Basu had granted a stay. On that plea, they wanted the CBI investigation to be stayed. On the initial stage, the Supreme Court did not stay the investigation, only said no precipitative action should be taken. And the last day when I argued the matter, the present Chief Justice asked the State Council, you must categorically answer this. And for that only 10th is a get fixed.
Now, categorically answer what?
That the creation of supernumerary post is an outcome of corrupt practice.
Now, where is the division bench judgment observation?
This is the judgment.
Page. Find it out.
Answer capable.
May I just only one? The division bench judgment.
No, I want to see the division bench only.
দাও আমি বের করে দিচ্ছি দাঁড়াও হ্যাঁ
Sorry, Kishore. You go ahead.
355.
So this part, 355, Mr. Dotto, 355 direction for CBI inquiry is also under challenge by the state.
Yes.
Easy.
So this is not classifying what kind of supernumerary post in respect of what. এটা বন্ধ করো তো।